Monica Maraj from Gauteng, an attorney who gives us advice on child maintenance.
Hello Denver, and thank you for having me back on the show.
Monica, what is child maintenance?
Maintenance is an amount of money that a person has to pay towards another person based on a legal duty to support that person. A legal duty to support a person is based on the relationship between the parties or between the persons, and the need to be supported and the ability for the other person to support. So, for example, a father of a child has a legal duty to support his child if the child needs to be supported and he is able to support that child.
Who is entitled to receive maintenance?
So, Denver, all children are entitled to receive maintenance from their parents, irrespective of whether the child is born during a marriage or out of wedlock. Adopted children are also entitled to receive maintenance from their adoptive parents. However, they are not allowed to receive maintenance from their biological parents. So, parents are allowed to receive maintenance from their children if the parents have little or no income, and only if the children have the financial means to do so. So basically, children may receive maintenance from their grandparents if the children's parents are not so well off or are not in a position or unable to support them, and the grandparents are financially able and capable to provide such support. Spouses are also allowed to receive maintenance, Denver, and I think this is also very important, and they're allowed to receive such maintenance from each other during the marriage or after the marriage in terms of whatever the divorce order or divorce decree states.
Where can an application for maintenance be done?
So the process is actually very simple. An application for maintenance can be made against the defaulting party or the defendant or the person who must pay the maintenance at the maintenance court or the district court where the complainant resides or lives. That is, a person may apply on behalf of the child purely because the child's probably a minor. So it's where they reside or where they work in that jurisdiction of the court.
Monica, who can apply for maintenance on behalf of a child?
The parents can apply, Denver, the guardians, the caregivers of the children or the child can apply for maintenance on behalf of such a child.
What expenses can be claimed in respect of a child?
So when considering the amount of maintenance to be claimed, the following should be taken into account, and I think these are really important. The expenses for food, clothing, accommodation, medical care, education, and I think provision for electricity, water, linen, cutlery, the washing of clothes, and just overall maintaining the child. The standard of living and financial means of the parents should be considered when calculating the amount that is being claimed for maintenance.
What should a person take to court when applying for maintenance?
So Denver, there are a few important documents that one must have on hand. For example, an ID document of the complainant, complainant's contact details such as telephone number, home address, and if you do know where they work, maybe the work address as well. If maintenance is being claimed for a child, the birth certificate of the child must also be taken along. If maintenance is for the spouse or for a spouse that is being claimed, the marriage certificate and the divorce decree where the maintenance order was granted. A full list of expenses and any proof of same, such as receipts, must also be provided. The complainant or the person asking for the maintenance, they must provide pay slips and proof of other income. So as much detail as possible to the court so that it can really make the process easier. And I think the most important thing is having the income, having a list of expenses, and having that income on the list.
What happens after an application is made?
So the maintenance officer will inform the defendant or the person lodging the complaint of the application, and then they will hold an informal inquiry to what the complaint is about while the defendant or the person against the complaint is present. The defendant must then take any proof of their income or expenses, for example, bank statements, salary advice, receipts, and so on, to the informal inquiry. The purpose of this informal inquiry is to assist the complainant and the defendant, so to assist both parties in reaching an amicable settlement. If a settlement is reached, an agreement will be entered into between the parties, the complainant and the defendant, which will then be made an order of court. If a settlement cannot be reached, the maintenance officer will then place the matter before the court for a formal inquiry to be held. The court will then consider all the facts and evidence of both parties, the complainant and the defendant, look at the evidence of the claim and decide whether the maintenance should be payable and the amount of such maintenance. The court will then make an order reflecting the decision. In this instance then, the complainant and the defendant must both be present in person at the informal and formal inquiry, and both of them will be allowed to have legal representation so they so wish to have so. If the defendant fails to appear at the formal inquiry at court, an order which the court deems appropriate, so the court will make an order which it deems appropriate, may be given in that person's absentia, so in their absence. It will not be necessary for the complainant or the defendant to appear in court if the consent is given in writing to the maintenance order being granted.
How can maintenance order be enforced?
So if the party or the defendant fails to make a payment of the maintenance in accordance with the maintenance order, the following remedies are available to the complainant. So firstly, there's a warrant of execution for the attachment and selling of the defendant's property, such as his or her furniture, their car, and so on. There's an emoluments attachment order. So this attachment is basically against the defendant's salary for payment of monthly maintenance, attachment of the debt, attachment of money owed to the defendant by a third party other than a salary. For example, rent owed by a tenant to the defendant. And I think finally there's also criminal prosecution, the laying of criminal charges against the defendant based on the failure to comply with the maintenance order. And I think it's important to note at this point that this is a court order, so it has to be complied with. When using one of the above remedies, the complainant must have a copy of the maintenance order available to prove that the defendant has failed to make payments. If an order was granted for any of the above remedies, the details of the respondent must be given to any business who is involved in credit ratings, such as the credit bureaus whose object is to grant credit. So this must be brought to their attention as well.
Monica, until when must a child be maintained?
So a parent's duty does not end when a child reaches a particular age, but when the child becomes actually self-supporting. A child will generally be considered to be self-supporting when he or she starts to work, but there are instances where continued support is necessary in accordance with the child's need for further support. And just to name a few examples, or to give people an indication, if the child is mentally or physically challenged, then obviously they would need ongoing support.
Monica, finally, if anyone out there is uncertain, where can they go?
So they can go to the family court or any magistrate or district court for further guidance and assistance. There are always court officials available to guide you in the process and assist you to fill out all the forms and to follow the process.
Thank you, Monica, for joining us.